recommendations made to improve that, and some disciplinary actions that were recommended, and what's happened on that. And I would expect these gentlemen to know that was over in the East Coast. I would just like to finish up with a brief mention of what the ACLU is asking to be changed. This is a bill called the SAFE Act that is co-sponsored by, I believe it's Stensenbrenner, Republican of Wisconsin, Craig of Idaho, another Republican, and another gentleman who I can't recall, a Democrat. And what it calls for is at Section 206 that these roving wiretaps that were also mentioned earlier, that these roving wiretaps simply be tied to an individual person who might use several phones. And if they don't know who the person is, at least what is going to be wiretapped. In other words, what is going to be done. So asking to specify, instead of just saying you can wiretap anybody you think you might want to wiretap, or anything you want to wiretap. The Section 213 delayed notice that was also mentioned in the presentation. They're right, delayed notice has been around for centuries. What was changed with the Patriot Act was it basically removed some of the specific language that had been used by federal courts to varying degrees. Circuits had different standards. That basically said when could notice be delayed, and what we're asking for in the SAFE Act, in which Republicans and Democrats are co-sponsoring, is simply a statement that one, there needs to be a specific statement regarding destruction of evidence, endanger to life, things such as this, and also that the delay is going to be 7 days with an opportunity to renew it 7 days in 7-day increments, provided that the Attorney General can continue to show to the court's satisfaction that it is necessary to satisfy the conditions that we're asking to be put in the law. So a very reasonable change, not getting rid of it, not saying that you can't do it, and you're going to have to tip off the terrorists. That's not what we're talking about. Section 215, this is the one I mentioned where they want to make it so that you have to have specific and articulable facts that the person that you want to get library records of or other records is actually an agent of a foreign government, that there are facts alleging that. Because the FISA court is not about finding criminals. It's about apprehending terrorists and foreign agents that are trying to do damage to our country. And then finally, there's some sunset provisions that are in there that would expand more sections of the Patriot Act to be sunsetted at the end of 2005. So those are some of the sections that want to be changed. Now, I do also want to wrap up here by just saying that there's a section 802 of the Patriot Act. It deals with the definition of domestic terrorism. And it basically talks about that someone can be a domestic terrorist if they commit a criminal act in the United States territory that is dangerous to human life. And I want to ask a question, maybe to start off this situation. I learned earlier today that 3 peace activists in Des Moines have been served with grand jury subpoenas by the United States Attorney's Office for the Southern District. These are individuals who have participated as Catholic workers and Americans Against Service Committee, Quakers, in nonviolent civil disobedience against the National Guard for several years. They have a long record of nonviolent protest. And they've been served with a grand jury subpoena, which means that they have to go to the federal courthouse on February 10th, and they have to go before a grand jury without an attorney and answer questions. And I know that Mr. O'Mara cannot talk about grand jury proceedings because they are secret. But I do think it's important that we all consider that we need to give the benefit of the doubt because we don't know what this is about. But I would venture to say that if it turns out that this grand jury investigation doesn't amount to much, and if it's really more about intimidating dissenters in this country, then there's going to be a lot more people than just the ACLU who are going to be upset. Because that's not what goes on in America. But let's hope that this grand jury investigation that's taking place in Des Moines, Iowa, where peace activists with a long history of nonviolent, pacifist civil disobedience are being brought before a federal grand jury and being forced to answer questions, that this is not something that we will need to be ashamed about later. Let's hope.
Thank you.
Thank you.
Now comes your time to be able to speak. We have a microphone set up. Please feel free to walk to the microphone and we'll take 3 or 4 questions. Or we could be here until midnight and we get snowed in. Please state your name if you would, if you're comfortable doing so, and state your question. I fear not. There.
Maybe not. Herman Kornbach of Ames. Question for either of the U.S. attorneys. You repeatedly mentioned this FISA court. This is the court, am I correct, that reviews the search warrant, wiretap, etc. requests from prosecutors and investigators in this area. Is that correct?
No. No, the FISA court is a very specialized court. Look at it this way. Everything we do in Des Moines or Cedar Rapids does not have to do with the FISA court. Neither one of us can have anything to do with the FISA court. General wiretap applications, pen registers, search warrants, trap and trace devices, stored electronic communications go to judges that are appointed and serve on general criminal and civil cases in the federal judiciary in these locations.
Yes, but in the national security area, the FISA court does review requests of that type.
Yes, yes, they do.
Okay. So they are, it would be fair to say, they are the bulwark that is supposed to protect the constitutional rights of the target of any investigation.
Well, they're federal, yeah, they're federal judges. Yeah.
Mhm.
Appointed by a variety of presidents, past presidents.
Okay. My question to you is this. How many requests has the FISA court handled, and how many requests have they denied?
I don't know.
We don't, it's secret. We
Yeah,
we
I
have
don't
no
know.
access to it. That's what we've been trying to tell you.
I don't think they deny many because the preparation is exhaustive and they have to be approved by the Attorney General or somebody at the deputy high level. But not many because they have done their preparation thoroughly.
Mm-hmm. Ben, do you have the current number?
I know it, but
Oh, it's
I'm
been
not
tried. I don't
positive.
think it's many.
I think it's something like 170, and there's only been 12 that were even questioned, and none of them were denied outright. So every single application over the last 25 years.
No denials whatsoever.
Right.
It strikes me that that's not much of a watchdog of our basic constitution.
Well, they're federal judges, and if I'm sorry, if you don't trust the federal judicial system, that's all I can say. There are federal judges; they're appointed by a variety of presidents.
Yeah, and you have to understand it. You know, all the laws are based in the Constitution. That's what the ultimate test is here. And it's we the people. So that's you and that's me, and I certainly want my constitutional rights protected. In fact, I take an oath to protect yours, and I live by it. I think that's overlooked here. And I'm not going to make any personal attacks. I've spent most of my career working to protect your civil rights. I really have. FISA court, 170 cases over how much time?
About 25 years. That's the number
Now,
that
how do
comes
you
to my
think
head.
that
It could be
compares
incorrect.
to the docket of the Southern District of Iowa? 400 or 500 cases a year in criminal court. We're talking about an infinitesimal number of cases nationally. And U.S. Attorney Larson is right. They really have to prepare to present these. And then it is a matter. Do you trust the judicial officers to make the decision the presidents of both parties have put them in place to make? Do judges make mistakes? Absolutely they do. Do they routinely make mistakes? I don't think usually. And it doesn't just require, as a regular wiretap can be looked at by one judge. That's not usually going to happen at a FISA court. It's a panel. That's an increased effort to protect civil rights in an area where there is not a defined crime that's being looked at.
Mr. Gillespie, next question.
Yes, I'm Michael Gillespie. I'm a journalist. I have a general question this evening. And let me preface it by saying that I think we all want to trust our government. We all want to trust the Department of Justice and all law enforcement agencies. And we all appreciate that since 9/11, there hasn't been another terrorist event of that scale. But yet, many people are troubled by what appears to be the zeal of Attorney General Ashcroft in pursuing more power than the government seems to need. And I think, given the gravity of the tragedy that happened on September 11th, few Americans would fault Attorney General Ashcroft if there had been any accountability for the massive intelligence failures on the part of the United States government that led to the tragedy of September 11th.
I'm sorry, I don't understand your question.
I haven't asked a question.
Oh.
I thought,
Okay.
did we get equal time then?
My question is, how can you gentlemen justify Attorney General Ashcroft's apparent zeal for what appears to many people to be excess power, given the fact that there has been no accountability whatsoever for the massive intelligence failures on the part of law enforcement in this country and intelligence agencies in this country that allowed the attacks on September 11th to happen in the first place? If there had been accountability for those failures, there would not be the fear that is palpable.
Okay. We want to get as many questions as we can. Do you have a response to that?
I have a couple responses.
Yeah.
Number one, I'm not really here to personally defend Mr. Ashcroft or anyone else. I think I prefaced all my remarks by saying I don't want to get into personal attacks. Number two, I want to disagree seriously with Mr. Stone's analysis that there are areas in which the judiciary does not have almost exclusive jurisdiction without judicial intervention. For any of you who read cases of law, the United States Supreme Court in 2003 decided the case of Young Joon Kim, Hyungjoonkim. Now, it doesn't pertain directly to the Patriot Act, but there are at least 3 cases in the 2003 Supreme Court that touch upon areas in the anti-terrorism effort. If you read this case closely, you will see that in matters of immigration, in fact, the executive branch can have, according to the Constitution of the United States as interpreted by the United States Supreme Court, almost exclusive jurisdiction without the intervention of the judiciary, even including in some circumstances the right to habeas corpus. These are not my words. These are the words of the United States Supreme Court. Number two, in the area of military law, the civil courts of the United States generally do not have jurisdiction. So that you'll notice the first 2 situations that Mr. Stone spoke about, Guantanamo Bay and enemy combatants, are not covered by the Patriot Act. That's not the issue here. Those are areas of law that are going to be decided by the United States Supreme Court, as they should be, as I support. Number 3, I'm not at liberty to really agree or disagree with some of your comments, but I think I do disagree with some of them. Number 1, Attorney General Ashcroft is not responsible for all of the intelligence agencies of the United States. That's very clear. Number 2, you're presuming facts that I don't know that have been demonstrated as to where the fault might lie with regard to intelligence failures. An intelligence community that obviously was built or dismantled long before the current administration. And what my politics are or are not have nothing to do with that. In fact, I'm not a presidential appointee. I'm a career attorney for the Department of Justice. I am, in fact, in a protected position. I can have my opinion without any sense of undue allegiance at all to any current administration.
Is this kind of like having tenure?
Yes.
Okay. I want to be very cautious. We have lots of people who want to speak here, and I think we're probably going to come back to some of these. I would also remind people we need questions, and preferably as concise as I would have you write them in my journalism class.
Maybe even more concise than that.
As we say in journalism, short is good.
Oh, hello, I'm Sarah Orley, and I'm afraid I've never taken your journalism class, but I can make it short. I was just curious if you could briefly describe what kind of access law enforcement officials had to library records before the Patriot Act was passed.
Sure.
Thank
Yeah,
you.
yeah,
Thank you.
sure. Well, they have access through routine subpoenas. I don't know if you've ever subpoenaed any library records. I don't think we have, but the government has. The Kaczynski bomber case, they looked at library records. There are several examples. Who was the fella in New York that shot all of the people?
Son of Sam.
Son of Sam. They looked at library records there. So yeah, it's pretty common. That's the part I'm most puzzled by, all the excitement, but you can get a routine. You've got to be working on a case, a legitimate case, but you can get those records now. I found myself at a dinner at Iowa City, and I was sitting next to the person's public relations director for the library in Cedar Rapids, which has half the population. Des Moines checks out twice as many books, I might point out. And I said, "Are you all excited about this?" Well, no, that's no big deal.
I think we
question.
could currently get them under administrative subpoenas, grand jury subpoenas, or court orders without any reference at all to the Patriot Act.
Next
If I
question?
could just make a quick comment, the difference is that, going after records of people that you suspect of being criminals is one thing. Being able, under the law, being able to go after the records and the medical records, the genetic records, Ashcroft has admitted could be achieved under this, library records, being able to get those without having to prove that the person you're getting them from is suspected of a crime is intolerable in this country, and it can't be tolerated.
Well, then you're back, of course, to not having any confidence in the federal judiciary.
Well, no, I think the
I'm
federal
sorry,
judiciary should
I'm
be
sorry.
the
Yeah,
federal
yeah.
judiciary should be involved in this. That's
Yeah,
the
they are.
problem.
They are. They are.
They certify.
No, they are for the
They
FISA. If you're going to
certify-
get library records for a foreign intelligence investigation, you're going to go to the FISA court.
Yeah, and
Again,
you
it's the judges now.
And all you have to do is demonstrate that it is sought for an ongoing criminal investigation. It's
I
right
think
in
that's
section
as opposed
215.
to
It's
probable
right there.
cause, as opposed to demonstrating probable cause.
If you think you're not interested in it, then you should let the law be changed. As I said,
Look,
that
we
requires.
Yeah, go
don't
ahead.
want to digress. We have
Yeah.
lots of questioners. Next
Yep.
question.
All right, Sam.
I can tell it's going to be real interesting reception. Y'all better stick around and have punch.
I'm Sam Pongone, and I was just wondering, is it possible or likely that there's a system that would bug every phone, let's say in a city or a nation, and after someone said a keyword such as drugs or bomb, be activated for an investigation? So, like widespread bugging among cities or states or nations.
There's something, the National Security Agency, I saw something on 60 Minutes. That's about all I can tell you. There is some kind of listening worldwide by satellite that picks up a lot of that stuff, and there are keywords, but that's just according to 60 Minutes. So
Yeah,
I
but if
don't-
bomb is the key word, all they'll get is a lot of stuff about Janet Jackson's show at the Super Bowl.
I don't know what that has to do with, yeah.
You cannot listen to other people's wire or oral communications without unless again you're in a FISA court situation, without going through the Department of Justice to the highest levels and showing probable cause to intercept that person for specific crimes that already exist before you intercept, and then you have to go to an Article 3 judge, a full plenary power judge, and you have to have the judge approve it. In my experience, which is fairly substantial in the area of electronic surveillance, the average wiretap affidavit I deal with is probably somewhere in the neighborhood of 60 pages long, replete with facts as to why we should be able to intercept communications of this person for these specific crimes for a limited period of time and reporting to the court usually every 2 weeks.
All right, so considering that, then there shouldn't be anything,
You're not worried, are you?
bugging. No, just a little nervous, but not bugging like a whole city can, presuming that the whole city isn't full of.
Well, I'll also tell you this as a practical matter, it's not free to do this. It
Yeah.
costs to do it. So by the time you put the paperwork together with the cost, the reality under the current situation of doing what you're saying is a virtual impracticality. It just probably wouldn't happen.
These are, it's a big deal, it's rare. We were visiting a dinner, and I was U.S. Attorney for 7 years before in Northern District and didn't even have a wiretap. They're rare, big, expensive deal. I wouldn't worry one bit. I'd worry more about the next course you got, frankly.
Next question? Thank you.
Good evening. My name is Jonathan Greenlee, no relation to the College of Journalism. I'm actually a civil engineer. But I did have a question that could probably be answered by anyone on the panel. As far as this new information sharing capability goes between agencies such as the CIA and the FBI, is there any concern now that information that might not be so accurate as has recently come to light with our foreign intelligence services, could that information now be used in domestic courts where people are supposed to be granted the security of having a trial based on facts and fairness?
Facts. Well, they have to get permission to use it. I don't understand the last part, facts and fairness.
Basically what I mean is that maybe that wall was originally there, and that's what I'm trying to get here, is maybe that wall was originally there to separate what might be less solid foreign intelligence information is held by agencies such as the CIA from entering into the area of grand jury subpoenas in the FBI, where cases are investigated involving domestic citizens, and where everything that's carried out in the courts involving citizens here in the United States should really be based on facts. Is there any sort of concern to be had now that false information or information that might not be so certain from foreign intelligence might seep into or be transmitted to the FBI and used in domestic cases?
For routine, I think the concern went more toward what one of the earlier questioners had about why didn't we do something right away sooner, and there was some indication we couldn't. It was classified, but there were concerns we couldn't exchange information quickly, and that concern outweighs your concern. And Congress voted to overwhelmingly pass the act. I'm sure they considered all that. Believe me, they seem to consider.
And you are
everything.
talking about investigation as opposed to charging or trying to prove up a crime. It's a huge difference. Instinct is still a huge part of successful law enforcement.
And it's important to realize that I'm by no means an expert, but I understand that FISA court admissibility in trials for criminal charges, that's still an issue, that the Pitch Act didn't necessarily say anything the FISA court hears can be brought in as evidence. I think there's still some standards there, I'm not sure. Because it's a very legitimate concern. You're talking about intelligence that you shouldn't be convicted on.
Thank you.
My name is Nenad Kostic. I'm a professor here. If we take a microscope and look at shifts in the law over the past couple of years, then perhaps Patriot Act does not represent a major shift. But if we broaden our frame of reference and look at trends over the decades, the shift is huge. When I immigrated into this country in late 1970s, I was proud of the welcome that foreigners enjoyed in this country. At that time, if you were a foreigner or an alien, and within the United States, the burden of proof was on government to throw you out if they wanted to deport you. Every foreigner had full protection of the American laws simply by virtue of being within the country. Nowadays, not only foreigners are under a priori suspicion, witness all the fingerprinting and photographing, but also American citizens are being arrested and held incommunicado, as we heard in the previous presentation. This is a huge shift. This country has turned from one that is devoted to freedom and civil liberties and welcoming outsiders to a country closed, almost xenophobic.
Is there a question?
No, this is the prelude.
Okay, then let me ask you a question.
Yes.
At all times you were present in this country, were you here legally?
Yes, I was.
Do you think it has always made a difference under the United States Constitution whether or not you're a foreign national here legally? The answer is yes, it has always made a difference. Do you think it makes a difference under the United States Constitution whether you are not a permanent legal resident alien as opposed to any other status of alien in the United States? The answer is yes. None of that has changed.
I think it has changed.
I reference you to, again, Young Jun Kim. It's the most recent case I could find that addresses these issues. That's the law of the land.
We lived in California in the early 80s, and I knew from personal observation that children of all aliens in California had right to education, well, certainly right to public education. Nowadays, in the same place where I used to live, in Pasadena, California, this is not the case. So there has been a change.
Okay, but that's not constitutional law.
It is the law as felt by the citizens of the country and as perceived by the world.
Okay.
Constitution, I agree with you, the Constitution does not defy right to public education. But we are citizens, we view our government as one. Back to my question. I spent first half of my life in a benevolent communist country, which was still rather intolerable. I hear now from Attorney General Ashcroft the same things that I heard and I was ashamed of when I lived in California, namely, from his own mouth, that when one criticizes the president, one works for the terrorists and plays it to their hands. I want to ask you, gentlemen, who are attorneys, since your boss says that, is that the policy of the Justice Department? Since the Attorney General said that, is it really, does the Justice Department have a priori suspicion against citizens who criticize the president and his handling of terrorist legislation?
Response?
No.
No, we haven't started any. I think, as Stephen said earlier, one section particularly, we don't look into First Amendment rights. I was down at Farmers Market in Des Moines one Saturday morning, and a woman's passing out flyers to vote for her for the school board. She was the socialist candidate for the Des Moines school board. And I asked her if her brand was the same as that in Russia or former Soviet Union or Cuba or North Korea. She gave me kind of a dirty look. But no, we don't investigate people based upon their First Amendment rights. It's her right to stand there and pass out leaflets, and we didn't discuss the Attorney General.
So does it mean that the statement by Attorney General
No,
does not
I don't.
obligate you?
I'm not
It
familiar with
means
this
that I
statement.
think intelligent people discriminate between political comments and the law and the enforcement of the law. My oath is to the Constitution of the United States and to protect you. That's my job.
Nanette, I think we need to
Just one more
let
word.
some other
When
people
Attorney
ask
Gen- I
questions.
consider Attorney General an officer of law, not a politician. And when he speaks about who does what and what is admissible and what is not, to me, this is the law speaking, not the politician speaking.
My name is Robert Baum. Repeatedly, we've been told that we should be comforted that federal judges are our safeguards in the Patriot Act, and that we should trust our judges. I'd like to remind the panel that if President Bush is not reelected, another president will be enforcing the statutes of the Patriot Act. Imagine, if you will, a president who would appoint a man to promote a sitting judge to a higher court in a recess appointment, who improperly interfered with another judge's discretion in sentencing a man for a cross burning in front of the house of an interracial couple. Imagine for a moment a president whose vice president goes duck hunting with a judge who is a Supreme Court justice who's about to rule on a case directly involving the vice president. Imagine a president who appoints the sons and wives of Supreme Court justices to federal government positions. And imagine that new president doing those things. And I was wondering whether you would find any disturbing lights going on in your minds about the independence of the federal judiciary.
Personally, I have lots of issues about both the past administration and the current administration as a career law enforcement official. But unfortunately, fortunately, this is the country in which I live, and I would choose to live here over any other country in the world. And I do think we need to protect our civil rights, but I haven't heard a thing out of you about the Patriot Act, so I don't know where to start to begin to answer your question.
Next question.
Hello, Robert McMahon. I'm a student here. Thank you for taking my question. I guess all the speakers spoke a little bit about how there was a differential introduced in the Patriot Act. I think it existed before that. But between the ways the government can proceed in an investigation or prosecution based on a person is suspected or charged with terror-related crimes or not, I'm wondering, the gentleman from the Iowa Civil Liberties Union mentioned that there were quite lengthy standards spelled out in the Patriot Act. I was wondering what those were, how those would apply to, for instance, someone arrested on, I don't know, immigration violations, what prosecutors would have to prove for that person to be charged or to be investigated using these statutes that are tied to whether or not that person is a terrorist or suspected of terror-related activities.
That's kind of a difficult question to get through. I'm not sure. I'm going to answer it as this way. When someone is an immigrant, the standard for bringing them into custody and ultimately deporting them is a much different standard than the standard that applies to citizens who are being charged with crimes, whether they're terrorist crimes or other crimes. And so it's different. The Constitution still applies to all persons in the United States in varying degrees in different contexts. But if you are a foreign national in this country and you're found to have violated a law, sometimes a very minor law, that can be grounds for deportation. That's often that's what happened to a great extent after 9/11. But I can't really answer, and I don't know whether Steve or Chuck want to do that either. But the distinctions you're talking about are highly technical, and I don't know them, and I would have to look them up and share them with you later.
I think if you're going to charge somebody with a crime, it doesn't matter. I really think that. It doesn't matter if you're a foreign national, permanent legal resident alien. If you're going to charge them with a crime, you have to have probable cause to charge, and they have to be proven guilty beyond a reasonable doubt. And all the due process protections associated with charging with crime apply. So, for example, the case I was given at the very end, Wan Israf Wan Mohammed, was a Malaysian national charged with a crime in the United States, not a United States citizen. He was entitled to and received all of the substantive and procedural due process protections that you would be entitled to. But if the person is being picked up for an immigration status violation, for example, they are not United States citizens, and the Constitution and the Supreme Court have been characteristically clear on that. There's a difference there. But if it's a crime, that's a bright line. If it's a crime, you're entitled to substantive and procedural due process.
Thank you.
May I pose a quick follow-up?
Sure.
Okay. Then, I guess you mentioned there were some courses of or avenues of investigation. Was it the wiretaps? I really should have taken notes. That applied to terror-related activity and some that didn't.
Yes.
Actually, if you want to, I think if we want to do it that detail, we might want to do that after while we're chatting.
Okay.
Sure.
Thanks. I think we have 2 more questioners.
I'm Tyler Stamp, and this is a question for Mr. O'Mara. You said during your speech, I guess, that in certain circumstances like war or in crime that rights can be taken away from a person. And I was wondering what rights those were.
The question I was posing, and I'm going to suggest to you as a we the people, not as a prosecutor. One of the things we have to deal with in society about the anti-terrorism efforts, where's the distinction between a crime, where's the distinction between a war where you declare a person to be a combatant? Now, Patrick is really more the expert on that because that's military law. The key, though, is there has to be a beginning point. And under that beginning point, you have to be able to demonstrate something to put the person into the classification you're claiming they're a part of. And certain of those attempts, for example, have the right of habeas corpus, where you can challenge your detention. It literally means bring the body before me to see if the body should be released. I'm not an expert on the military side of it. That's not at all my expertise. But, for example, even with regard to foreign nationals in this country, if they're here illegally, they don't have the protections of the law very much at all. They probably have, if they're charged with a crime, they're going to. Right. And we made that distinction thanks to the very good last questions we had. But if they're picked up and can be administratively removed, they will still have some rights. But the United States Supreme Court has said those are almost none, and that in fact the Congress can define it to be no judicial intervention. Read the case. Those aren't my words. Right. But if a person is a legal permanent alien, they are at home in this country, much as you or I are at home in this country, and they should have protections much as you or I should have in this country.
Thank you.
Now we have 2 more questions.
Yeah, it's great.
I'm Michael Falk, a graduate student here in Ames. And on the topics of due process of foreign nationals, I guess I had 2 questions. The first one is, if a foreign national is detained, you mentioned if they met the definition of a terrorist. First off, who decides that? And then my other question is, when they are detained, it seems like the burden of proof is placed on the foreign national to prove that they shouldn't be detained. I'm just curious what the rationale behind that is. Thank you.
I think, and again, this is not something we deal very much with the Patriot Act in Iowa, but my understanding of the way, basically the Attorney General Congress defines, the Attorney General applies, and the Attorney General applies it through what is currently called Immigration and Customs Enforcement. That's really who applies it. Again, though, if they're not released within 7 days, they either have to be charged, or a deportation removal proceeding has to be begun, or they have to be released within 7 days. And as you enter any one of those procedures, there are certain rights that attach. But again, there's a huge difference between being charged with a crime, being a legal permanent resident alien, and being someone who is illegally in the United States as to what due process you would get. But at the end of that 7 days, some rights should attach. I think Viet Dinh has said that one of the fundamental rights that should attach in all, he's one of the authors of the bill that used to be with the Department of Justice, now with the Georgetown Law Center. He indicated that one of the fundamental rights that really should attach is the right to representation, so that you can have an attorney help you through the minefields of the American legal system. So there are certain rights that almost everyone would have, but it really varies according to who you are in that circumstance. But the 7 days is very important, as is the 6 months. And those not the timelines, but the fact that there are incremental times of review is something that this Supreme Court case I keep referring to deals with, in terms of who's entitled to that and who isn't.
And our final questioner.
Hello, my name is Arti. I just have one question. So, since this Patriot Act is such a big and a huge act, so, what is the government doing to educate and try to create awareness among the aliens who are there in the country? And also, in case of, I was just wondering if there is an organization out there represented by aliens, maybe trying to protest against the Patriot Act, or even formation of such an organization would be violation of the Patriot Act.
Well, there's various organizations that exist for various nationalities. There's Arab groups, Muslim groups, African groups, and they're making efforts to educate the people from their countries. The ACLU has filed on the Patriot Act. The ACLU filed the first lawsuit challenging portions of the Patriot Act, and it had to do with Section 215 and the fact that mosques in Detroit and Michigan have seen a decline in their attendance, and the Muslim charities people are afraid to give money, and so that's a challenge. Actually, just last week, the first federal judge ruled a portion of the Patriot Act unconstitutional that had to do with material support to terrorist organizations and advice and expert advice, and so international groups are making an effort to educate their people. I'd suggest looking on the internet, finding the organizations, and obviously the ACLU has some foreign language. I have 7 different Middle Eastern languages with Know Your Rights brochures.
So I might mention, if you're really interested in following up on who's a combatant, what can Americans do or not do, there's an interesting book about the Americans that were determined to be the title of the book, Shadow Enemy Spies, and then were tried and executed during World War II. And the leading Supreme Court case there to cover many of these areas is cited in there. The whole case is set out in there, Quernin, U.S. Ex parte Quernin. Yeah. So I can show you this after. Kind of interesting part of our history. You all must have quite a bit of interest to sit here for, 2.5 hours? Or an hour? Yeah, no, hour and a half. Seemed like it, yeah.
If I could, I'll make a closing comment, and I really feel compelled to, because I think that there was a gross misrepresentation of the situation, and again, I don't want to get into any personal dispersions or attacks. There's no question that there are people that demonstrate at Stark Armory down by Des Moines, and whether or not there's a grand jury, this is the absurdity of the law sometimes. Whether or not there's a grand jury investigation of that, I could not tell you, because Federal Rule of Criminal Procedure 6E precludes me from even acknowledging whether or not there's an investigation. So it's incredibly brave of someone to raise that issue when I can't comment on it, even whether or not it exists. But let me tell you what I can comment on. I can comment to you that the public record clearly shows that a large number of those people have protested there a number of times. And that every time they've crossed onto federal property, I guarantee you that is either a misdemeanor or a felony offense of federal law, and they have never been prosecuted. What Mr. Stone neglected to tell you when he was telling you about the peaceful demonstration is that the public record will show that a deputy sheriff was severely kicked and has suffered serious injury to a knee. That's the public record. That fact was not brought. That's record. Don't take my word for that. Go look it up.
Are you finished?
I am.
Okay, first of all, I did explain to the people that you cannot comment. And if you're going to use the standard that I can't comment because there's a law that says you have to keep secret that there's a grand jury investigation, then that is a real recipe for a secret government. So that's kind of unfair. And I made a very express statement that we need to give you the benefit of the doubt. And we need to see where this goes. And yes, there was an allegation of a severe kicking, as you describe it. I have certainly heard from several people who were there that is a gross misrepresentation, and that is something the government has alleged. And by the way, at this demonstration in November, previously, whenever this happened, about twice a year, I think. Father Frank Cordero. The police show up, they talk about how to do it, they say we're going to step here, you arrest us.
Because we're getting feedback.
All right, and so anyway, at the last one, they had something like 40 officers there, 17 of them in full riot gear, for the exact same people they've been dealing with for 10 years.
That is, I'm going to ask you to hold that comment because, frankly, it doesn't relate to what we're here to talk about tonight, and that's the USA Patriot Act.
Well, my question before was whether or not domestic terrorism is he can't answer this, I know, but
right.
I think that's a good question. Is this an example of the Patriot Act being used in the United States and having a domestic terrorism investigation under the new definition? And because the absurdity of the law, as Steve already mentioned, he can't answer that. But it's a good question.
I can't talk about the specific case, but I can tell you that there are at least 3 statutes that I have personal knowledge of because of an incident at the Air National Guard base last year, which was not prosecuted federally, in spite of a lot of pressure to do so, that there would be allegations of crimes outside of the Patriot Act. The grand jury is used for criminal investigations. It's part of the beauty of our system. If there are differences of facts being alleged about what occurred in any situation, and there's a potential for federal prosecution, you must go federally. It's constitutional. You must go to the grand jury. And the grand jury helps sort out whether or not there's a violation of federal law. So that has nothing to do with the Patriot Act. That's just the way the criminal system works in the United States, and that's a good system.
I have the joy of the last word because I'm the moderator. And I will tell you, while I am a state employee and eat at the state trough, I'm also something of a coward because I would probably never have the courage to run for public office or serve in the public capacity that these two gentlemen are serving. I think we have seen tonight a demonstration of what it means to be a passionate, intelligent, dedicated citizen from 2 very different perspectives. The tough part for you all is you need to be too, and your presence here tonight indicates that you are. There is a wealth of information about the Patriot Act, pro or con. It will come before Congress. The SAFE Act, I think, will be debated. And you have to leave here tonight with, I think, the heaviest burden of all, and that is to continue to educate yourself and to continue to participate in democracy. When Congress debates whether the Patriot Act will be extended, expanded, contracted, or ended, please don't let that debate occur without making your sentiments known to your elected representatives in Congress. Citizenship 101. It's tough, but aren't you glad we live here? Thank you very much. Let's have some punch and cookies.
My question is, it's snowing yet, though.
Oh, boy, I don't know.